in Division 8, and that's at the Boulder County Justice Center. We'll see you there. You'll get a new mandatory restraining order before you're released, okay?
9 a.m. August 7th. I'll be there.
Okay. You'll get an appearance bond with a reminder, okay?
Appreciate it. Thank you for the PR bond.
Okay.
Waplev, and there he is again. For most people, getting arrested once is enough motivation to make some life changes. But for sovereign citizens, jail seems less like a consequence and more like a frequent flyer program. What's especially impressive is how quickly Daniel managed to find himself back in legal trouble after his previous court appearance. Most people learn from experience. Sovereign citizens treat experience like a challenge to do even worse next time. The House of Kaminsky continues producing courtroom content at a rate Netflix would be jealous of.
Is Cody McJunkins. This is case number 26T3157.
Okay, Dustin Kaminsky.
Your Honor, Mr. Kaminsky has elected to represent himself in this matter.
Okay. All right. Mr. Kaminsky is with us in 25M1570. Mr. Kaminsky appears pro se. Ms. Alexander's here for the people. We're here today to set bond, and I've issued a mandatory restraining order that restrains you from any contact with the named victim. Do you understand and acknowledge that?
Yes, I do. I did notice on the restraining order that it has an address of 246.5 Main Street. I do not reside there.
You don't?
No, I do not.
So do you have another address you can give us? Don't give it to me right now, but can you write it down?
No, I'm homeless.
Okay.
Live here within Boulder County.
Do you stay at a shelter ever?
No, Arapahoe, Cherryville, is where I reside.
Can we change that and reissue it without an address for him? Because he doesn't live at the address on it. Okay, we'll reissue it. Okay.
Good afternoon, Your Honor. I'm Justin Anthony of the House of Kaminsky.
I'm going to listen to what the people want in terms of bond, and then I'm going to hear from you about bond, and I'm not going to hear from you about anything else, okay?
Okay, I understand.
Ms. Alexander?
Your Honor, we would be requesting a $1,500 secured bond, noting the allegations as well as the defendant's criminal history, as well as the lack of ties to this community. We do have concerns for him not showing back up to court, so we think a low secured bond is appropriate.
Okay, thank you. Do you have anything you want to say about bond, sir?
Yes, I'm Justin Anthony. As a living man, I state and affirm that I'll show up to court until the case is dispositioned. I'm a resident of the Front Range for 54 years.
Okay, here's what I'm going to do is I'm going to set bond in the amount of $5,000 PR. That's a high PR bond.
Yes.
So it's giving you an opportunity to comply with two things: with my restraining order, which means no contact with this victim.
I understand.
If you're currently taking any mental health treatment or medication, continue with it, and come back to court. And I will set this case for 9 a.m. on August 7th. In Division 8, and that's at the Boulder County Justice Center. We'll see you there. You'll get a new mandatory restraining order before you're released, okay?
9 a.m. August 7th. I'll be there.
Okay. You'll get an appearance bond with a reminder, okay?
Appreciate it. Thank you for the PR bond.
Okay.
Waplev, and there he is again. For most people, getting arrested once is enough motivation to make some life changes. But for sovereign citizens, jail seems less like a consequence and more like a frequent flyer program. What's especially impressive is how quickly Daniel managed to find himself back in legal trouble after his previous court appearance. Most people learn from experience. Sovereign citizens treat experience like a challenge to do even worse next time. The House of Kaminsky continues producing courtroom content at a rate Netflix would be jealous of.
Is Cody McJunkins. This is case number 26T3157. Good morning.
Hello, Your Honor.
Okay, looks like you're here for 4-point careless driving, and you were wanting to set your case for trial, correct?
Yeah, for the record, I just wanted to state that I'm the natural person here on special appearance. So, Your Honor, I have some questions about this, why I'm here today. Is this a criminal or a civil matter?
Well, I'm not going to answer too many questions today because we're setting your case for trial. What I need to do is get you into the court where you can get that jury trial set.
Right, Your Honor. I'd just like to know the nature and the cause of the charges and why I'm here to be able to defend myself correctly.
Absolutely.
And no, my
So,
apologies for interrupting.
no, you've got two traffic infractions. One of them is the license plates expired with a temporary permit. The other one is a license plate not automatically readable. Those are both punishable by fines and points. The third charge is careless driving resulting in injury, where you could be charged, or excuse me, you could be sentenced to up to 90 days in jail. That charge has a 4-point penalty if you're convicted of it.
So are you saying this would be a criminal charge then?
It's a traffic case where the rules of criminal procedure apply.
Okay, Your Honor, is there a warrant, an affidavit, or a declaration in support of that warrant?
There's no warrant.
There's
You
no
were-
warrant.
You were charged, you were issued a summons and complaint back on July 10, 2026, around 9:30 in the evening here in Douglas County by the Colorado State Patrol. That's the charging document which started the case.
And you said that was July 10th that it happened, or July 10th that the case was filed?
July 10 is the date of violation.
Do you have a copy of the citation that was issued? I never received any copy. I'm not
Well-
even sure why I'm here. That's why I'm kind of confused.
You can get that from the clerk of court.
According to the Constitution of the State of Colorado, 1876, you're saying this is a criminal matter, and therefore, if it's a criminal matter, there should be a warrant and an affidavit or declaration in support of that warrant.
Not if
Is
you
there
weren't-
one?
Not
Is
if
it
you weren't arrested. Not if you were not arrested. In
right?
other
But this
words-
is a criminal charge, is it not?
Yeah, and that's why you were given that summons and complaint, which started the case. It's what gave jurisdiction to the court and over you to be able to hear this case.
And who is the injured party that brought this case, Your Honor?
Well, I don't know what you mean by injured party. I can tell you the deputy is the one who started the case.
And who is the deputy, Your Honor?
See his name here.
And there's no complaint
here it is.
in connection with that citation from the
Hold on,
deputy, Your Honor?
let me answer your question. It's Deputy Cox.
Sorry, Your Honor.
Deputy Cox, C-O-X.
Thank you, Your Honor. And to ask again, there's no complaint from Deputy Cox when giving that citation?
No, it's not necessary.
So what is being requested? Is there a fee being requested, or is equity in this case being requested?
No, what's being requested by the summons and complaint is that you be prosecuted for that careless driving with injury.
Okay, Your Honor. So for the record, I want it to be known that I am challenging the state's jurisdiction, subject matter jurisdiction, and also personal matter jurisdiction to bring this case forward. I am requesting discovery. I have requested discovery, and I need discovery to be able to properly defend myself, Your Honor.
Yeah, you don't even need to request discovery from the court. What you need to do is go down to the district attorney's office. They would be happy to set that up.
Yes, Your Honor. I was just making record of that. This is a court of record, correct?
It is.
I will be requesting a court reporter for every hearing and also transcripts for every hearing, including today.
Understood. You're entitled to transcripts. You're not going to get a court reporter because we use what's called the FTR, which is this system. If you want your own court reporter, you can make a motion in the trial court. I'm going to set you into Division G as in George on September 15, 2026 at 9:30. Let me get back to the discovery.
Your Honor, real quick before we move on, you
Well,
said
hold on.
this was a criminal case.
Oh, hold on. As far as discovery goes, do you know where to get that?
Yes, I'm able to email the prosecutor on
Now,
the case.
before you leave today, you're going to go all the way down the hall. There's a little zigzag. The district attorney's office is near the end on the right. Go in, talk to the person at the window. That's where you just request discovery.
I reserve all rights.
Now we move on to Cody McJunkins. Every time this guy appears in court, he looks like he's been losing a fight with basic hygiene. The amazing thing about sovereign citizens is that they'll spend hundreds of hours researching fake legal theories but somehow never find 10 minutes to research personal responsibility. You can immediately tell this hearing isn't heading anywhere productive because the defendant walked into court believing he's the smartest person in the room. That's usually the first sign of disaster.
I'm going to give you an advisement, and at the end, I will ask you how you would like to proceed with the case, okay?
Thank you.
All right. Ma'am, you need make no statement today. Any statement you make can and may be used against you. You have the right to an attorney. If you're deemed to be indigent, you have the right to request the appointment of counsel or consult with the public defender before any further proceedings are held. Any plea that you make must be voluntary and not the result of any undue influence or coercion. You have the right to bond in this case, and in fact, you're out of custody. I will remind you of your bond conditions are that you're to attend all court dates, comply with the protection order, comply with monitored sobriety, shall not possess or consume alcohol or drugs, shall not commit a felony while on bond, and sign a waiver of extradition. You have a right to know the nature of the charges, and after this advisement, I'll let you know what the charges are and what the possible penalties are. You have a right to a jury trial, the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offense or offenses charged against you were committed by you. Lastly, if you're currently serving in the U.S. Armed Forces or if you're a veteran, you may be entitled to receive mental health treatment, substance use disorder treatment, or other services as a veteran. I'm now going to pull up the complaint and let you know what the charges are and what the possible penalties are. The district attorney filed a complaint against you on July 27th, 2026, and it has 3 different offenses on it. The first offense is count 1, menacing as a class 5 felony. That count reads as follows. On or about July 4th, 2026, Vera Walsh, by any threat or physical action unlawfully, feloniously, and knowingly placed or attempted to place Tamara Keeler in fear of imminent serious bodily injury by the use of a bludgeon in violation of the Colorado Revised Statute, Section 18-3-206. If you pled guilty or were convicted of that offense, you could be sentenced to a probationary sentence with up to 90 days in the Fremont County Jail, or a community corrections sentence in the presumptive range, community corrections or Department of Corrections sentence in the presumptive range from 1 to 3 years. If you were subject to the aggravated range or enhanced range, it could be as high as 6 years. Count 2 and count 3 charge you with a class 1 misdemeanor. So I'm going to read those counts to you, and the penalties will be the same. Count 2 harassment says on or about July 4th, 2026, Vera Walsh with intent to harass, annoy, or alarm Tamara Keeler, unlawfully struck, shoved, kicked, touched, or subjected the victim to physical contact in violation of the Colorado Revised Statute 18-9-1111A. Count 3, harassment is a class 1 misdemeanor, reads as follows. On or about July 4th, 2026, Vera Walsh with intent to harass, annoy, or alarm Christopher Hennon, unlawfully struck, shoved, kicked, touched, or subjected the victim to physical contact in violation of the Colorado Revised Statute 18-9-111, subsection 1A. The class 1 misdemeanors could carry a probationary sentence with up to 60 days in the Fremont County Jail, or a jail sentence up to 365 days, and that is in both of those counts. Ma'am, would you like time to hire an attorney or complete the application for a public defender?
No, Your Honor. I'm so sorry. Good morning, Your Honor.
Let me just
If it may
ask you,
please
because
the court.
let me just ask you one thing. I don't want you to say anything that could harm your case.
Understand that.
If you're interested in communicating with the district attorney, I'll give you time to do that. If you wanted to make any admissions, we'd set it for a different date. So right now, I just don't want you to say anything that could harm your case.
I understand that. I'm so sorry. I can't see very well. I just have a brief statement.
I just don't want you to say anything that could harm your case.
Okay. I identify as the beneficiary and sole trustee of the all caps name Vera Lee Walsh.
Now, this is where things get even better. One of the most common sovereign citizen questions is, who's the injured party? The problem is, that question becomes a lot harder to ask when prosecutors are literally discussing a named victim. Reality tends to create serious problems for people whose entire legal strategy depends on pretending reality doesn't exist. Instead of focusing on the actual charges, she seems determined to argue her way into a worse outcome. That's a bold strategy, and history suggests it's not going to work.
And I would like to make a statement, a brief statement. If
I don't
that's
want you to say anything about the facts of your case. Are you going to tell me something about the case itself?
For the protection and security of all parties involved, I have submitted evidence of this individual's compliance to sobriety monitoring as you have requested. I have completed one UA and have another today. I must complete by 4 p.m. on this day, July 29th, 2026. I greatly look forward to seeing everyone again at the next scheduled hearing or deposition. I am an American. And I have a constitutional right, and that right shall not be infringed. And I believe that there is some sedition regarding this case. And I am asking the courts not to infringe upon these rights that I have, because that's not nice. So I would like to invoke Article 6, Section 2, and claim infringement.
Okay. Let me ask you how you'd like to proceed with the case. Do you want time to speak with counsel or time to apply for an attorney from the public defender's office?
I would just like to know when the next time you would like me to appear it would be.
I have to know whether or not you want to represent yourself or you'd like time to speak
Represent
to
myself.
counsel. Okay, I'm going to go over an advisement. All right, ma'am, do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, that one will be provided to you if you, free of charge, if you qualify as indigent?
I would like to decline that.
Okay,
offer.
but I'm just asking if you understand that.
I do not understand it because I've made it very clear that when I was incarcerated on the 20th, that
Just asking if you understand that you have a right to have an attorney on this
I do
case.
not speak legalese. I just know what the law is.
Okay, do you understand that you have a right to have an attorney in this case?
Yes.
Okay. And that if you qualify as indigent, that the court would provide an attorney to you free of charge?
Yes, Your Honor.
All right. Do you understand the charges against you? I understand you might disagree with them, but do you understand the charges that I just read to you and the possible penalties?
Yes.
Do you have any legal training?
Just my elective in high school, which was constitutional rights of the individual.
Okay. How far have you gone in school?
I have my GED and I have, acquired many skills throughout my 41 years on this land.
41 years old and still acting like every authority figure is a substitute teacher she can argue with. What always amazes me is the confidence. Some defendants spend years studying law, pass difficult exams, and still hire attorneys because they understand how complex the legal system can be. Then along comes someone who watched a few YouTube videos, skimmed a constitutional article, and suddenly believes they're ready to defeat trained legal professionals. That's not confidence. That's the legal equivalent of watching a cooking show and immediately applying for a job as a head chef.
Are you under the influence of any drugs, medication, or alcohol that would affect your ability to understand these proceedings?
No, Your Honor.
Do you understand that if you want an attorney to represent you and you want time to apply for a public defender, that I would give you time to do that?
Yes, I understand.
All right. Do you wish to consult with an attorney before you make the decision to waive counsel and represent yourself?
No.
Do you understand criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
I'd prefer to stick with the advisors that were appointed to me by the court.
Okay. And I'm not sure what you're referring to, advisors appointed to you by the court?
I have some evidence to submit it.
Do you have an attorney in a separate case?
I do not, but
Okay.
Fremont, I've been in touch with Fremont County, Mr. James Connell, I believe, and also Lisa. I have the name here. Lisa Holgerson.
Okay, I just have to make sure you have no certain rights before I accept your waiver of counsel. So I'm going to keep going over this with you. Do you understand criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
I do.
All right. Do you understand that you have a right to remain silent and that anything you say can be used against you in court?
I do.
All right. Are you, let's see, you should understand you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. Do you understand that?
Yes.
Do you understand you have a right to confront the witnesses against you and to cross-examine them?
Yes, ma'am.
All right. Do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? All right. And Ms. Walsh, is it your decision today to waive your right to counsel and represent yourself?
Yes.
We'll find that Ms. Walsh has made a voluntary, knowing, and intelligent waiver of a right to counsel. Ms. Walsh, just let you know at any time, if you would like the assistance of counsel on this case, all you have to do is ask, okay?
Thank you so
You
much.
certainly can hire your own counsel as well. I can do a couple things in setting your next court date. If you'd like time to communicate with the district attorney, I'll give you time to do that. If you'd want to enter a not guilty plea, I'd send your case up to the trial court to do that. Would you like time to communicate with the district attorney?
I would just like to finish the 30 days before we proceed.
Okay, the options are you can have time to communicate with the district attorney about your case,
Yes.
or I can
that's
send
fine.
your case up to the trial court to enter not guilty plea and start fighting the charges.
I would like to, the
Time to-
first option.
Time to
Please, I'm so
communicate with the
sorry.
district attorney, you all right? You'd like time to speak with the district attorney?
Yes.
All right.
please. If we can schedule a time, it's not the best time right now. because
All right. Ms. Walsh, would you be able to meet August 6th at 10 a.m. at the district attorney's office?
I am, if someone could please provide me with the address.
It's right, if you walk out of this courtroom to the left. So second floor of the courthouse.
Oh, beautiful.
Just
Thank
right
you.
there, yeah. All right, but that date and time works for you?
Yes.
All right, so that's when you'll meet with the district attorney. And that's where you also get the discovery in your case. So any police reports, body-worn cameras, any kind of evidence that the state's trying to use against you, okay?
Thank you.
All right.
And that's where this hearing wraps up. The reality check hasn't fully arrived yet, but it's definitely in the mail. Representing yourself in court can be difficult, even for intelligent and prepared people. Doing it while relying on sovereign citizen theories is like trying to fix an engine with instructions written by a fortune cookie. Unfortunately, the court system isn't required to entertain fantasy just because someone believes in it very strongly.
Next, Stephen Crawford. Can you hear me okay?
Yes, sir.
Thank you. Could you confirm your date of birth for me, please?
January 30th, 1966.
Thank you. That matches what I have here. I'll find that's Mr. Crawford appearing via WebEx and appearing without an attorney in case 26R112. You're appearing today, sir, on a traffic infraction. That's a charge of speeding 20 to 24 miles an hour. The speed limit potential penalty is a fine of $200 plus court costs and 6 points that will be assessed against your driving privilege, unless you've had some other recent speeding convictions, in which case the number of points goes up typically by 2, depending on the number. I see that you filed a copy of your Texas driving record, and that shows the most recent conviction as 2017. You would qualify for the deferred sentence here.
I'm sorry, I will not or will?
Well, so you would based on the driving record, but normally I only give the deferred sentences for up to 19 miles an hour over the speed limit. So once we go 20 and up, I don't typically give deferred sentences.
Your
Let's talk
Honor,
about
can I
the-
request some leniency on the behalf of the court? You know, I visit your state maybe 6 to 7 times a year. We have property up there, never been in any trouble. I am a good driver. It, you know, was a very short lack of paying attention. But Your Honor, I mean, come on, 6 driving record when, I mean, I haven't had any moving violations since 2017. I'm sure you can show me a little bit of leniency here.
That's possible, sir, but first we need to talk about the rights that you have in your case and make sure that you understand those.
Okay.
You do have the right to remain silent. Any statement that you make may be used against you. You have the right to be represented by an attorney at your own expense. If the only charge against you is a traffic infraction, which it is here, then you cannot be represented by the public defender's office, even if you were to qualify financially. You have the right to deny the allegations and to have a hearing before this court. At that hearing, your guilt or liability would need to be proven beyond a reasonable doubt. You have the right to testify, to subpoena witnesses, to present evidence, and to cross-examine any witnesses testifying for the state. If you enter a plea to the charge, that plea must be made freely and voluntarily, not as a result of any undue influence or coercion. And if you choose to plead guilty or no contest, you would waive your right to have a hearing and also waive your right to any appeal. If there's any hearing set after today and you fail to appear, the consequence may include a default judgment against you and reporting of that judgment to the Department of Motor Vehicles. That's the rights that you have. The options that you have are to request more time if you want to consult with an attorney at your own expense, to plead not guilty. In that case, we'd set the hearing that I mentioned. The officer who wrote the ticket needs to come and prove the charge beyond a reasonable doubt. If they don't show up, the case would be dismissed. If you don't show up, default judgment against you. And you also have the right to plead guilty or no contest. I won't grant you the deferred sentence. I would offer you a reduction 1 level down. That's 10 to 19 miles an hour, the speed limit. And that's a 4-point violation. It's a $135 fine plus court costs. That's instead of the $200 fine and the 6 points. Any questions about the rights or the options you have, sir?
I have no questions at this time, Your Honor.
Okay. What would you like to do today?
I'd really like it to be dismissed or deferred adjudication.
Okay.
Well, I mean, Your Honor, like I said, I'm a good driver. There was no threat to public safety at 7:30 in the morning. The freeways were clear. There was not bad weather. I'm a good driver.
And now we arrive at Stephen Crawford. Apparently, Stephen wants everyone to know he's a great driver. Normally, I'd be willing to consider that possibility. However, attending a Zoom court hearing while driving down the highway isn't exactly the strongest evidence in support of that argument. In fact, if someone asked me to describe a bad driver, person participating in court proceedings while operating a moving vehicle would be pretty high on the list. Maybe let's focus on the road before focusing on proving legal points.
I'm the son of a retired law enforcement officer. I'm just at the 6 points on my driver's license, even 4, that just seems a little obsessive to me, or excessive. I'm sorry would be the right word. And I'm just asking for a little bit of leniency on the part of the court, Your Honor.
I treat everybody the same. So I'm offering you the same thing I would offer anybody else.
So you can bring the speed down to 19 and then give me a deferred?
No, sir. You could plead guilty at 19, $135 fine plus court costs, and the 4 points.
Your Honor, quick question. Is this a criminal court?
Yes, sir, it is. You're here on a civil charge.
Who might the injured party be, sir?
I'm not appreciating your attitude, sir. So I got a full courtroom of people. Stop talking when I'm talking. I got a full courtroom of people who are waiting for the nonsense that you're doing right now. So I don't have a lot of time for it.
Sir, this is the United States Constitution. This isn't nonsense. You took an oath in office. Everybody took an oath of office.
And you can show up here in person,
sir. Criminal trial, there has
you can
to
show
be
up here in person if you want to do this. So do you want to enter a plea today of guilty or not guilty, or you show up here in person?
Are you not going to answer my question, Your Honor?
You're talking when I'm talking.
I simply asked a question. If this is a
You
criminal
asked the
case, then
question
who
while
is
I
the
was
injured
talking,
party?
sir, so I didn't hear it.
Okay, may I ask it again?
Go ahead.
If this is a criminal proceeding, then who is
It's not
the
a criminal
injured
proceeding.
party?
I answered that question.
I'm in a
It's not
criminal court,
proceeding.
am I not?
This court handles all kinds of
So-
things. You're here for a civil infraction, a civil traffic infraction.
A civil traffic. All right, I will plead no contest.
Okay. The elements of that
for
charge,
the
sir, are
offer
that,
date.
okay, let me know when
Go
you're
ahead.
done and
I'm
I'll
sorry.
start talking.
My apologies, sir. I'm not used to doing this Zoom thing.
Okay. It's hard for both of us, but the issue is that everything gets recorded. So if we're both talking at the same time, then the record doesn't get made and then we don't know what happened if we need to come back. If you wanted to appeal this, you wouldn't have the opportunity to do that if we didn't have a good record. So we can't talk at the same time. If you want to plead no contest, I would accept a plea of no contest to the reduced charge. And sir, the elements of that are that on or about the date charge. That's May the 25th of 2026. Here in Rio Grande County in the state of Colorado, that you are operating a motor vehicle at a speed that was greater than was reasonable and prudent under the conditions existing at that time, specifically 10 to 19 miles an hour over the speed limit. And that's the amended count 1. Potential penalty for that, a fine of $135 plus court costs and 4 points would be assessed against your driving privilege by the Department of Motor Vehicles. Any questions about those elements or the potential penalties?
Negative.
Okay. Then to that amended count 1, how do you plead, sir?
No contest.
Anybody forcing you to plead that way today?
Negative.
Are you under the influence of any drugs, alcohol, or medication?
Negative.
And do you understand by pleading guilty today or pleading no contest, you are giving up your right to have a trial in this case?
Affirmative.
Thank you. I'll accept the
Your Honor,
no
quick-
contest plea as,
Quick question.
sir.
Being that I am an out-of-state resident, who is it on the bottom of this summons or citation, however you refer to it in Colorado, is that the place that I would go to pay this fine?
I'm going to give you a phone number to call to pay the fine.
Okay. Would they accept credit cards as well?
Yes, sir. And you can set up a payment plan and pay it over time, or you can pay it all at once. It's up to you.
Okay. What is that phone number, please?
Okay, hang on. We got to finish the process. So I'll accept the no contest plea as knowingly, voluntarily, and intelligently made to enter judgment for the amended count 1. Accept that as a plea of convenience. And sir, is there anything that you want to tell me before penalties imposed?
Negative.
Thank you. I'll impose that $135 fine and add the court cost. The phone number is going to be 719-657-3394. 719-657-3394. And you'll call them before 4 p.m. today. You either set up a payment plan or pay it in full. And if there's nothing else, Mr. Crawford, I wish you the very best.